Background. Federal laws and FINRA rules are designed to guard against both money laundering and the financing of terrorist activities. Money laundering is a serious crime. It can take place at any time and in all facets of the financial sector. Money laundering occurs when individuals or businesses attempt to conceal the origin or ownership of funds that have been derived from illegal activity. During the money laundering process, illegally obtained funds are disguised in an attempt to make them appear legitimate. Money launderers seek to legitimize the proceeds of these criminal activities by moving them through financial institutions and financial systems. Terrorist financing may also involve using legitimate funds to finance terrorism. This is a crime and is sometimes referred to as reverse laundering. Attention. Question 1. Is money laundering a serious crime? Yes or no? Customer Identification Program. As part of its anti-money laundering compliance program, your firm is required to have a Customer Identification Program (CIP) to verify the identity of all customers who open a new account with the firm. Your firm's CF includes procedures for obtaining specific customer identification information and for verifying the information in order to have a reasonable belief that the firm knows the customer's true identity. Even though firm procedures may vary, no individual is exempt from the CP. Your firm is required to verify the customer information it obtains. There are two methods that may be used to verify a customer's identity: documentary and non-documentary methods. Attention. Question 2. Even though firm procedures may vary, some individuals can be exempted from the CP. True or false? Documentary method. For an individual, the documentary method, at minimum, includes reviewing the customer's driver's license or passport to ensure that the information is consistent with the information the customer provided, and making a record of the verification information. For a business or institutional customer, a business license or articles of incorporation are examples of documents that are acceptable for establishing a customer's identity. Other examples are partnership agreements, trust agreements, LLC operating agreements, or other industry standard identifying information pertinent to the specific legal entity. Your firm may require more than one document for verification purposes. Attention. Question 3. Under documentary method, individual and business customers require the same documents. True or false? Non-documentary methods that can be used include obtaining information from a consumer reporting agency or other database, cross-checking references from another financial institution, or obtaining an audited financial statement. If a customer's identity cannot be verified by the documentary method, an explanation should be included in the customer's file and/or the new account application, along with a note of the non-documentary method S used. Attention. Question 4. There is nothing else we can do if a customer's identity cannot be verified by the documentary method. True or false? Additional customer identification information for high-risk customers. Your firm may require additional information or actions before opening an account for certain high-risk customers. Examples of some customers that might fall into this category are potential customers located in or conducting transactions with persons in high-risk jurisdictions, politically exposed persons, PEPs, or customers associated with politically exposed persons, or customers who are foreign financial institutions. Attention. Question 5. Customers who are foreign financial institutions are in high-risk jurisdictions. True or false? Your firm may ask that you take one or more of the following actions for high-risk customers. Review passports or other identifying documents for individual customers or the officers, directors or beneficial owners of institutional customers. Search public or private news databases for information about the customer or its officers, directors or beneficial owners. Obtain and review the customer's financial statements. For example, if your customer is an audited institution, you may request a copy of their audited financial statements. Contact other financial institutions or advisors such as accountants with which the customer has current or past business relationships. Obtain and check any references the customer provided. Review the PEP's employment history, sources of income and wealth. While doing business with PEPs is permitted, your firm must have procedures for conducting additional due diligence on these individuals. Attention! Question 6. One of the actions include contact other financial institutions or advisors such as accountants with which the customer has current or past business relationships. True or false? Assessing money laundering risk. The extent of verification that must be done in the time frame in which it must be completed will vary based on your firm's assessment of the money laundering risk presented. When assessing risk, there are several factors that your firm may consider, including the customer's location, the nature of customer's business, the types of accounts the customer is opening, the expected trading volume and activity, and the types of identification information provided. Attention! Question 7. When assessing risk, there are several factors that your firm may consider, including the nature of customer's business. True or false? Reporting suspicious activity. Time is of the essence when it comes to reporting suspicious activities. By law, your firm is required to report a broad range of suspicious activities within set time periods in the U.S. 30 calendar days from the time the firm determines that the activity is suspicious. Your firm does not need to confirm that a crime has been committed before it files a report, and you do not need evidence that a transaction involves illegal activity before you escalate the situation. Attention! Question 8. By law, your firm is required to report a broad range of suspicious activities within how many calendar days? Anti-money laundering laws and regulations prohibit you from informing customers or others that a SAR has been prepared or filed. This is called tipping off and can result in severe penalties. You should also not inform customers that their account has been identified and referred for potential suspicious activity. This means that if a third party, for example, colleague, registered representative, media or vendor, contacts you for information about the situation, you should refer them to the individual or department in your firm that is responsible for compliance. Attention! Question 9. Anti-money laundering laws and regulations prohibit you from informing customers or others that a SAR has been prepared or filed. This is called tipping off. True or false? Willful blindness. Willful blindness is the intentional disregard of facts that could have led to the discovery of suspicious activity. This occurs when a financial institution or an individual deliberately ignores signs that an account is being used to launder money or for other criminal activities. Escalate and investigate any activity that appears suspicious according to your firm's policies and procedures. Do this as soon as possible, even if you have little or no evidence that the transaction involves illegal activity. If you suspect suspicious activity, you should report it to your firm. Attention! Question 10. Willful blindness is the intentional disregard of facts and may violate firms' anti-money laundering policies. True or false?